Prenuptial agreements. What they can and cannot protect. Thinking about a prenuptial agreement before you get married. You're not alone. According to the American Academy of Matrimonial Lawyers, 62 of attorneys in a 2016 study said they saw a significant rise in prenuptial agreements, also known as prenups. The largest increase in prenups, they said, was among millennials. How do you decide if you should get a prenup? Arming yourself with the knowledge of what a prenup can and cannot cover is the best way to protect yourself. A prenuptial agreement is a contract between two people who are engaged to be married that covers what happens to the individual's assets, financial or otherwise, in the event of a divorce. Prenuptial agreements are governed by the 1983 Uniform Premarital Agreement Act. It has been adopted by 26 states in an effort to create consistent state-to-state enforcement. Couples can include the following provisions as a part of their prenup agreement. Number 1, each party's rights and obligations in any property and the right to control and manage the property. If one spouse enters into the marriage with his or her separate property, there could be a provision outlining that maintenance costs post-breakup wouldn't fall on the individual who doesn't have an ownership interest. Number 2, division of property if the parties separate, divorce, or die. A beach house, for example, can be rented or leased by one spouse while the other is able to vacation at the same house during the summer. Number 3, spousal support modification or elimination. This could include short-term, long-term, or no payments. Number 4, creation of a will or trust and how that might impact the prenuptial agreement. Number 5, rights or ownership of life insurance policy benefits. Number 6, which state law will govern the agreement. Number 7, any other issue that doesn't violate public policy or a criminal statute. Where the couple would live or raise their children are examples. Reasons why you may want to have a prenuptial agreement. Some couples may have extra incentives to enter into a prenuptial agreement. Prenups provide protection in a variety of scenarios, including the following. Number 1, you have significant assets. If you have significant property half wealth, you may not want to equally distribute those assets in the event of a divorce. Number 2, you have significant debts. If you have significant debts in your own name prior to marriage, the prenup can designate it as premarital debt. Should a divorce occur, the spouse would not be responsible for premarital debt. Number 3, you have dependents, such as other children from a prior marriage or elderly parents. Number 4, you have a small business. If you have a small business, you may want to make certain that half the business doesn't go to your spouse in case of a divorce. Number 5, you plan to get additional education. Number 6, you want to protect family heirlooms. Number 7, you want to add lifestyle-specific clauses to require or incentivize certain behaviors. For instance, if your spouse engages in drug use, infidelity, gambling, or other harmful behaviors, a clause can be placed in the document to compensate a certain sum to the aggrieved party. These clauses need to be drafted carefully, and depending on the state, there might be some conflict on whether a specific lifestyle clause is enforceable. Number 8, you have pets. It can become contentious to determine pet custody. Couples can include provisions regarding pet ownership in prenups in the case of divorce. Reasons why you may not want a prenuptial agreement. Prenuptial agreements don't always provide the best protection for individuals. Here are some scenarios in which a prenup may do some damage. Number 1, both spouses weren't involved in the negotiations. If you are not both involved in negotiating terms or other aspects of the agreement, there is a chance it might heavily skew in the favor of one person. Number 2, it might cause discomfort and hurt feelings. The feelings prenups bring up can begin to color a relationship. Number 3, friction with extended families. In-laws might be particularly offended that their son or daughter is entering into a prenup and may assume the marriage is doomed even before it has started. Number 4, the prenup is conditioned on future events. Some of the events outlined in a prenup may or may not happen, and it is hard to predict financial and future circumstances. How do you bring up the subject of a prenup? There's never a perfect time to bring up the subject of a prenup, but having this uncomfortable conversation with your significant other before getting married could potentially save financial and emotional stress for both of you should you decide to divorce. Plan to have this conversation early in the engagement instead of a few weeks before the wedding. Couples who have significant individual assets or debts, dependents, and small businesses should definitely discuss a prenup as soon as marriage is on the table. Here are some ways to navigate the initial prenup discussions. Number 1, weave the conversation into a broader topic surrounding your wedding or marriage. Number 2, don't make a prenup sound like a demand. Number 3, be cognizant about timing. Don't, for example, do it a week before the wedding. Number 4, emphasize the idea of fairness. Do you need a lawyer to draft a prenuptial agreement? It is possible to draft a prenuptial agreement on your own, but be aware that it may be unenforceable if it is determined by a court that certain requirements aren't met. Evidence of technical errors, coercion, and disproportionate terms could invalidate a prenuptial agreement. In addition, certain states have complicated requirements for prenuptial agreements. Judges will evaluate a prenuptial agreement and decide whether it is fair for both parties in the event of a divorce. What does a prenuptial agreement cover? A prenuptial agreement, when properly negotiated, can protect the following assets and interests: retirement or education funds that either party may have accumulated before marriage, property that either party owns at time of marriage, property interests of any children from previous relationships, obligations of spousal support should the marriage dissolve, educational and religious upbringing of children born from marriage, finances of each party, and responsibilities should the couple decide to part ways, a provision that one spouse isn't obligated to pay the debts of the other spouse, handling an inheritance, ownership rights and life insurance, or disability policies. If a judge, however, feels that the agreement is unfair or conflicts with a legal standard, these provisions can be unenforceable. This can vary from state to state. What doesn't a prenuptial agreement cover? A prenuptial agreement does not cover the following: child custody or visitation matters, child support, alimony in the event of a divorce, day-to-day household matters, anything prohibited by the law. Is a prenuptial agreement enforceable? The short answer is yes. A prenuptial agreement can be legal and binding if executed correctly and in accordance with the law. Whether certain clauses are upheld will depend on state law. What is the enforceability of a prenup in a community property state? There are 9 states that are community property states: Arizona, California, Idaho, Louisiana, Nevada, New Mexico, Texas, Washington, and Wisconsin. This means assets are distributed equally in the event of a divorce. But if a prenup agreement is in place, the terms of that agreement override the community property rules. If you found this video useful, please like, comment, and subscribe to stay up to date for all of our latest content.